23129-303 and 23129-304.
Aren't you going to take a seat?
No, I'd rather stand.
It's your hearing, sir.
Is it okay if I stand? Is there something wrong?
Why do you have to stand so close to him?
The sign there that says no standing.
Oh, well, okay. I didn't know I was subject to those rules. I didn't agree to it. Anyway.
Okay, so there's a bench warrant.
You know what? I'm just going to take the seat.
Thank you. That makes us a little more comfortable. Is it uncomfortable if I stand up, Your Honor?
Well, depends on how you're going to act or behave today.
I'll have a seat. It's okay.
Okay, so you failed to appear for court multiple times in this case.
Now, Your Honor, just for the record, the named defendant is actual property, a registered trade name.
Oh, here we go.
And the case has also been certified as a fraud. I have court certified documents to prove that. That should be on the record. And that's the reason why it was certified to be a fraud, because the plaintiff is a foreign-owned private corporation, which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and there's an act of identity theft, and that's probably one of the reasons also why the state has acquiesced that both cases.
From the moment the hearing begins, you can sense the tension. The judge calls the case, and instead of a straightforward appearance, we get immediate resistance over something as basic as where to stand. It's a subtle preview of what's coming. The defendant frames himself as separate from the name on the docket, claiming it's merely a registered trade name. This is classic sovereign citizen groundwork. Create distance between the person and the legal identity. But courts operate on established legal recognition, not personal redefinitions. The judge listens calmly, but the foundation of this argument is already crumbling.
A foreign corporation known as the state of Washington.
Okay, so on the 9304, I am going to quash that one. He was in RALJ appeal status, and so I'm going to quash that one. But I do want to hear from the state on the 303 matter.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
Objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law in this country.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the...
Now the narrative expands. The defendant declares the case fraudulent, the state a foreign corporation, and himself a foreign sovereign. It sounds elaborate, even theatrical, but none of it addresses the core issue. He failed to appear in court. That's the anchor point. Courts deal in actions, not philosophical identities. The judge doesn't debate ideology. She sticks to procedural facts. If the state had accepted his claim, the charges wouldn't exist. Yet here he stands. When belief collides with documented court records, it's the records that carry weight.
Served the jail time.
And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter, and so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as first-hand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right, so can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
The land of make-believe.
Okay, so with respect to the 304 matter, which is still pending, what's your position on the warrant, Ms. Fredenberg?
The state was going to ask for that warrant to be served.
Objection to jurisdiction. The state has never proven any jurisdiction and has no jurisdiction or standing. So any requests or statements from any representative from the state are a nullity and a fraud. Jurisdiction is challenged. It must be established on the record. And it hasn't been, and it still isn't. You can do it now if you like, if you can.
Okay, so Mr. Haywood, you failed to appear many times in both of these matters, had many warrants quashed, and to be perfectly honest, I'm not confident that you're going to come back to court given the history here.
The prosecutor clarifies the matter. 4 days in jail were ordered, and he didn't report. Instead of acknowledging that, the defendant claims he tried to deliver the paper defendant to jail. It's an argument that collapses under its own absurdity. Jails don't incarcerate concepts. They hold people. The judge methodically untangles the confusion and focuses on compliance. This isn't about metaphysics. It's about a sentence that wasn't served. The attempt to reframe a simple failure into a bureaucratic conspiracy doesn't hold.
Communication between the acting prosecutor at the time and myself. I have plenty of emails. So in one case, he said he was just going to reschedule with the judge. I told him, reschedule whenever you want. I'll go ahead and be there, and I'll bring the defendant with me. And next thing you know, there was a warrant for a failure to appear. So there's been plenty of fun and games with the acting prosecutor at the time. So it wasn't just a matter of not bringing the defendant to the court. The prosecutor was intentionally sabotaging the scheduling process.
Well, the prosecutor doesn't handle scheduling, the court does. So the court ordered you to be here, and then you weren't. So...
Objection, the court ordered the defendant to be here. I am simply bringing the defendant to the court to help try to solve the problem. The fact that the registered trade name remains as a named defendant is an act of identity theft and fraud, and that's probably why the state has acquiesced that the case is a fraud. I have the documentation here with me today in case if they decided not to upload it to the court record.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself. Or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that.
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
Okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today, so that they won't refuse for the defendant to serve that time. I'm going to serve the warrant, and so we need a pretrial date, Madam Clerk.
There's no jurisdiction yet been proven or standing. Are we going to continue? That would be an act of fraud and treason.
Your Honor.
That's a felony. That's an arrestable offense.
I put both of them in one of our.
So we don't need anything on the 303. He's just going to serve a sentence.
Okay.
We just need the 304, and
Yes, I have
see
the
that.
defendant here with me today. You can take.
The back and forth intensifies as he insists the jail refused the paper. The judge, unwavering, states the obvious. The sentence stands. He argues identity theft, lack of jurisdiction, and absence of first-hand witnesses. Yet he represented himself at trial and was convicted. That fact undercuts his entire premise. You can't participate fully in proceedings, lose, and later claim the system doesn't recognize you. The courtroom doesn't operate on selective acknowledgement. Participation carries consequences.
Since I'm taking him into custody. So do we have anything in August?
Excuse me, Your Honor, are you testifying that I am the defendant under penalties of perjury?
I'm not testifying to anything.
Good. And here's the defendant right here.
All right.
And we can do August 24th at 10:30.
All right, I can change that.
Thank you, Your Honor.
So August 24th at 10:30 in the morning will be your next court date.
I will be here with the defendant, no problem.
You're going to serve those 4 days, and then you'll be released, and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I won't be here for the defendant on August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there
Is there any
with
standing
the
or
defendant.
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect.
Jurisdiction becomes the next battlefield. He demands proof on record, challenges standing, and labels everything fraud. But jurisdiction isn't proven through debate. It's established by law and venue. The judge references his repeated failures to appear, highlighting a pattern. Courts notice patterns. When someone consistently ignores orders, credibility diminishes fast. The defendant promises to return on behalf of the defendant, but that distinction carries no legal power. The judge reminds him plainly, you either represent yourself or hire counsel. No imaginary third option.
Okay, please go take a seat. Sonia Sesko, customer 231024002. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction that's been proven yet.
Please sit.
Are you threatening me with violence?
I'm asking you to sit down.
You don't have authority over the defendant. You have no authority.
What are you doing?
Mr. Haywood?
You're
I got things to do.
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of
Okay,
that?
well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but
Here, the blame shifts toward the prosecutor for scheduling confusion. But the judge corrects that immediately. The court controls scheduling. That clarification lands heavily. The defendant attempts to turn administrative logistics into sabotage, yet the record shows orders were issued and ignored. Courts function on documentation, not email interpretations. When you don't show up after being ordered, the consequence isn't philosophical debate. It's a warrant. Accountability doesn't dissolve because someone reframes the narrative.
got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, they're my voice.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please?
The judge decisively resolves the issue. The 4-day sentence will be served. A new commitment order ensures compliance. Even then, the defendant insists he is not the defendant. It's a circular loop. Deny identity, deny jurisdiction, deny authority. But repetition doesn't create legitimacy. The judge calmly schedules the next hearing and clarifies the outcome. The path forward is clear. Serve the time. Return to court. Procedure moves forward regardless of protest.
The name is same, but that's my registered trade name. I got all that documentation right here.
Okay, good. So we're going to carry this.
Okay. Yeah. This is the defendant technically.
If you want that, I can go with you, put everything private.
Hold on 1 second. That's taken care of.
We can figure it, we're going to get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need...
The tension spikes when he refuses to sit and questions custody. The judge states plainly, "You are in custody. If you leave, it becomes felony escape." That's not rhetoric. That's statute. Suddenly, the abstract argument meets immediate consequence. The defendant tests the boundary, but the warning is unmistakable. Court authority isn't symbolic, it's enforceable. In that moment, ideology yields to reality. The sheriff's presence reinforces what words already established.